I'm going to tell about structure of answers. You have it yesterday as well. Please write your illustrations wherever possible from bare ad. If you know case laws, write it. I'm going to tell you case laws today for every topic that we are going to cover. You can go through this PPT, and even if you write that one case law, it should be more than sufficient. Please go through all relevant sections of that topic because your long answers are going to be topic wise, and that's the reason why we are doing it in the same manner now for revision as well. Also, if you can write an example, you may go ahead and do that. Let's move on to the next slide, which talks about oral evidence, and I have included chapters along with the topic title, and you will find a judgment at the end of the this pertaining slide. So you can note it down. You can always write oral evidence is defined or explained in chapter 4, and you can start your answer likewise for every topic that you attempt. Now, oral evidence is given in section 59 and section 60. What is oral evidence? When a person appears in a court, he is an eyewitness to a crime that has happened. Whatever he says is going to be recorded in the court records, okay? And that is going to be taken as evidence. Now, it is oral evidence because he has spoken about it in the court. He has expressed whatever that he has seen, heard, or felt while the crime was going on. And since he's speaking, he's talking in the court, it is called oral, and it is recorded as an evidence in the court. That's why it is oral evidence. Now, section 59 talks about proof of facts by oral evidence. If you see your bare act, it will tell you that all those facts which the person is explaining or telling the court is recorded as a proof, as oral evidence. It will be taken on record. On record as in it will be noted down, and it will be printed on paper, and it will be bunched into the case papers. Now, all those contents of the documents and electronic records, as I mentioned yesterday, there is something called as electronic evidence, wherein anything in the format of electronic, such as CCTV, video, audio clips, anything that is there, that need not be proved in oral evidence. Anything that the person has personally himself experienced, seen, or heard is only taken on record as oral evidence. Anything that is written in a document or anything that is seen in a CCTV footage need not be explained or given in the court by that witness, and that is not considered as oral evidence. That's what section 59 is all about. Section 60 talks about oral evidence must be direct. He cannot say that my friend told me. Whatever he has seen, he has to explain that. So it has to be in a direct format. Only then it is admissible in the court of law. So I've written, saw it, heard it, perceived it by sense, or in that manner. Also, hearsay evidence. Exactly what I'm saying, that he has heard something from his friend cannot be admissible in the court of law. That friend can come as an witness, eyewitness to the crime or the incident that has taken place. But this person cannot say that I heard from my friend, because that becomes a hearsay evidence. He has heard from somebody else. So that is not taken on record as an oral evidence. This is all about the topic. I have given a judgment, Vigdomal versus State. It's a 1983 case. If you get time, you can write, or you can just mention this in your answer. And it says information given to the police by some person is not admissible unless the person himself is examined as a witness. That means he has to come to the court when summons are given to him or sent to him. He has to appear as a witness in the court and narrate the story or the incidents that he has seen, heard, or perceived by any sense. So we come to documentary evidence. Now, what is documentary evidence? Anything that is on a document is a documentary evidence. Your birth certificate, your mark sheets are your documentary evidences, ascertaining that you have done a certain course or you have gained some marks. When you apply to a law firm, say for example, or for a job somewhere, you give CV. CV is what you have made, but your mark sheets, your other documents like certificates, might have won some awards, maybe you have won best mooter award. All this will actually prove that all that you've written in your CV. So you're basically furnishing documentary evidences to prove your CV. So section 61 talks about proof of contents of documents. We have seen in section 3 what documentary evidence is. All, I'll just repeat, it means all documents produced for the inspection of the court. Such documents are called documentary evidence. Section 61 talks about proof of contents. Now, all those contents of the document may be proved, and they could be either primary or secondary evidence. So we are going to see what is primary and secondary even later on. I'll tell right now. Section 62 talks about primary evidence. So primary evidence is the real document. So say, for example, as I mentioned, your birth certificate, that what you have got from the authorities or the BMC, that is the primary evidence. And if you take a photocopy of that, that will become the secondary evidence. So 62 talks about primary evidence, 63 talks about secondary evidence. You can, maybe it comes for short notes, so you can go through your textbook, what exactly you can include as to what words you can write in your exam to get better marks, such as secondary evidence includes certified copies, copies made from original by mechanical process. That's what we in common language we call it Xerox. Third is copies made from or compared with the original. Fourth point is counterparts of documents as against parties who did not execute. And lastly, oral or accounts of the contents of a document given by some person who has it himself seen it. So basically it could be a photograph, it could be a Xerox copy. Certified copies are Xerox copies of the original case papers which are in the court, and you take it for taking further action. Say, for example, you have fought a case in Metropolitan Court and the order was against you, was passed against your favor. It was not in your favor. So what do? You take Xerox copies of the order from the court, which is called as certified copies because they put stamps and signatures and give you. You can take that bunch and go to the higher court, that is Sessions Court, for a revision application. So basically, secondary evidence is a copy of the primary evidence. Section 64 talks about proof of documents by primary evidence. Now, how important is section 64 is that it only means that documents must be proved by primary evidence. Even if you have a secondary evidence, you must always prove that it is relating or it is a copy of the primary evidence, and that is important. Okay. Section 65 talks about cases in which secondary evidence relating to documents may be given. Now, there could be certain cases where maybe there is no primary evidence with you, such as the document itself, but you will have to prove your secondary evidence and you can furnish it in the court of law. So I have included a case, Preeti Chand versus State. It's a 1989 case where a carbon copy, okay, that point in time photocopy may not be there, so it was a carbon copy of the primary evidence. So this case law talks about primary evidence and it being a carbon copy, how it is considered as secondary evidence in the court. Next slide is also about documentary evidence because you have some more sections in it. Section 65A talks about some special provisions as to evidence relating to electronic record. Now, you know this A, B are all added things because at the point in time when this act was made, there was nothing called as electronic records, electronic gadgets, as I mentioned yesterday. So what are these special provisions wherein we can prove that an electronic record should be taken on record of the court of law as an evidence? So you have to prove each and everything. You cannot just take one thing and say that this is an evidence. Okay. Section 65B talks about admissibility of electronic records. So basically it tells you what are the conditions. Maybe the record is in a printed format on a paper, it is stored, recorded or copied, maybe in magnetic media or optical media. These are all very technical words. Basically, they are trying to include everything from floppy disk to CDs, DVDs. Now we have pen drives, we have hard disks. So it could be anything. So all the plethora of electronic gadgets or whatever format we can save in. For example, you can save a photo in JPEG format, or you can save it in a PDF format, or you can save it in PNG format. So the format should not be something that is to be argued upon. The main content that is being stored, maybe an audio clip or a photograph or a document, that is to be considered. That's what section 65B talks about, wherein electronic records are admissible in the court of law in whatever these formats. Section 66 talks about rules as to notice to produce. So basically, this is about secondary evidence of contents of documents which are referred in 65, section 65, clause A. Okay, so there is some proviso given in this act wherein you need to know that when the document is to be proved in itself as a notice, then from the nature of the case, adverse party must know that he will be required to produce it. There has to be some knowledge to the other person that you will have to produce. In case you say you have a birth certificate, they will ask for it. They will not just say, okay, you have it. You will have to take it to, say, to college for taking admission, right? So you have to furnish it whenever it is asked for. So these are certain rules that are given in section 66, wherein if given a notice to you, you need to produce it in the court. You should be aware of that. Section 67 talks about proof of signature and handwriting of person alleged to have signed or written document is to be produced. So basically, if a document is, say, if it is thought to be alleged, means they are thinking that it is done to be signed or to have been written wholly or in part, it may be by any person, the signature or the handwriting of such a document and as is alleged to be in that person's handwriting must be proved. See, basically any signature, handwriting, everything has to be proved because it actually adds value to the document. If you have a will which does not have a signature, it's not valid. But if it is signed by the person who holds the property, then definitely it is a valid will and the property can be transferred in the person who is a beneficiary. So this part of having signature and handwriting to be proved on documentary evidence on a paper which is produced as proof in the court of law is very important. So whether it is signed or a written document, that's what they are trying to say. Say if it is a suicide note, it's a written document, right? So is it admissible in the court of law? It is only if you are successful in proving that the handwriting of the person is of the person who has passed away. If it is written by some other person, say for example, X passed away, and if the note is written by Y, it is not considered in the court of law, right? Because suicide note has to be written by the person who has actually committed suicide. So this is a very important section in understanding that every document has to be proved, whether it is in written format, whether it is signed, whether it is an electronic record like we saw in section 65. Now section 74 talks about public documents. Now what are public documents? Public documents are basically all those records or something that forms a part of an act. Act is, we are looking at all acts, right? So it could be given by any authority or by official body or a tribunal. Say an order of a mat court is a public document because it is in open court. An order passed by a sessions judge, it is in the public purview. You can go and ask for it. You can take certified copies. So it is a public document. There is nothing confidential in it. It can be given to anybody after following a due process. I have included the case law here talking about certified copy and how certified copy is considered as secondary evidence in the court of law. Kalyan Singh versus Choti, it's a 1990 case. Now we come to a very interesting topic in this whole Evidence Act, which is included in chapter 8, Estoppel. So basically what is Estoppel? Stop. So the court is, or the opponent is trying to stop the person from going back on his own words. Say for example, there is a witness who has appeared in the court of law and he has given a statement that he saw A killing B. He's done the murder. Now, this is what he has told in first place. Now, when he was cross-questioned, which we call as cross-examination, he cannot say, no, he wasn't present at that place. He's already confirmed that he was present over there and he's seen the incident when it happened. So on the next occasion, he cannot go back on his words and say, no, I wasn't there. If he wasn't there, he must not have seen the incident, right? So this is what is section 115, and that is what is estoppel. So this is what it is. Section 116 talks about estoppel of a tenant and of licensee of person in possession. This only, you can only just mention it in your answer. It's not really to be explained. It talks about specific cases where there is tenant and licensee involved. Licensee is basically like a person who is taking a shop on rent or a place on rent for running his own business. And a tenant could be anybody who's staying on rent at some place. So it talks about the tenant and the licensee who have the possession of the property with them. So they cannot tomorrow get up and say that, no, I never signed on any paper, or I have never actually gone through any rent agreement, license agreement, leave-in license agreement, which we call. That is what it is. Section 117 talks about estoppel of a acceptor of bill of exchange. Now, what is bill of exchange? Common example for bill of exchange is a check. So basically, you can exchange the bill and take money, or you can take certain amount in your account, may not be cash. That's bill of exchange. Payee or licensee. Again, it is talking about a licensee. So you don't have to really start to explain this. You just have to mention it in your answer 116 and 117. The idea behind estoppel is very important, wherein you have to really elaborate on section 115 as to what it is and how it is important. Because if every person starts denying their own statements given in the court, you just imagine what will happen in the court, right? So there has to be some device wherein we can say, no, you cannot go back on your statements, right? It's a rule of law. And of course, if the person goes back on his words, if he gives statement that he's seen the crime happening and then he denies it, then it does not give rise to any cause of action. Now, there are certain statements or there are certain processes or procedures which happen in the court and even before that, which give rise to cause of action. For example, you might have heard about Limitation Act. You have to reply to a notice within say 15 days or 30 days, whatever is mentioned in the notice. If it is a show cause notice, then you have to reply within 15 days if it is written in it. That's the limitation period of you to answer it. Maybe that the incident for which the show cause notice is sent, it's happened some 4-5 years back. So you cannot really approach the court of law for an incident that has happened way back in some year. So to raise a cause of action, you send a show cause notice and your limitation period will start from there. So estoppel says that if you go back on your words, if you change your statements as a witness in the court of law, it is not going to affect the case. You will be declared as a hostile witness and it will not give rise to any cause of action. This is very important for you to mention. Now, this estoppel principle was founded way back in 1837 in a case called Picard versus Sears. I have mentioned it here. You can write it in your answers. And also, I have mentioned the latest case of 2004 Karnataka High Court, Jindal Thermal Power Company Limited, Karnataka Transmission Corporation Limit. Now we come to chapter 10, which talks about examination of witness. Now this is very important. When you build your case, you have two important evidences in the court to prove. One is the documentary evidence and second is the witness. So documentary evidences are mostly very simple and direct, but witnesses could be little tricky. You have to really extract truth out of them. Maybe they are just believing in some wrong notion. Maybe they are lying. Maybe they are pressurized by somebody to lie. It could be anything. So you have to, as I said, extract the truth out of them. They might have given a statement, right? So you have to cross question them and get the truth. Section 135 talks about order of production and examination of witnesses, which is purely a procedure that is being followed by the court. And section 136 talks about judge to decide as to admissibility of evidence. That only means that you can furnish 100 evidences in the court, but are they relevant? As we saw yesterday, there is something called as relevancy. There is something called as facts and facts in issue. So all these things are to be considered by the judge. He has to apply his mind and then decide whether that evidence is admissible in the court pertaining to that particular case. Say, for example, there is a criminal who has like 10 cases going on in the court, different courts. Now, there may be some evidence which is valid in some other case and may not be valid in the current case that that judge is looking into. So he has to decide whether it can be admissible in the court as an evidence. There could be certain documents or there could be certain other things which would be furnished as evidence and they are not really valid or they are not really good enough to prove themselves as evidence in the court, and that the judge will decide. Now, very important section is 137, wherein you must have heard about this a lot of time from your seniors if you are interning. If not, even in movies you might have seen. Examination in chief, cross-examination, and re-examination. Now, examination in chief is basically the statement that is given by a witness who's come in the court. He's been summoned to come to the court and record his statement. So the prosecution will ask him questions and try to get the story. He will narrate the story. That's examination in chief. Now, it is up to the advocate of the accused to prove that he's lying or he is in some wrong belief, because you have to make your case stronger. And that's where you cross question him, right? This is what all our mothers do. If you lie to them, then they will cross question you and try to understand whether you're lying or you're telling the truth. So there could be some tricky questions and then you spot out the truth. So that's exactly what happens in the court. I'll give you an example. There was this witness who stated that he was, when there was a search going on in the police station of accused, he was present. He stated the name of the accused. He also told the court what all articles were found with the accused. And finally, these people, he's called punch witness. He's supposed to sign the search report. Now, when it came for cross-examination, he was asked the date when he visited the police station, whether he knew which police station he went to, who called him. Now, this all actually told whether he went to the police station in first place or no. Because police may say anything. It is ascertained by the story of the witness, right? The punch witness. So asking him these questions is going to really get the truth out. Then he was asked, what all articles were found? Did you see that those articles belong to that accused? Do you know the name of the accused? He is supposed to be well aware if this whole incident has happened in front of him. And if he answers that he is not aware, at the end, when he stated that he did not know the contents of the search report because they were written in Marathi and he doesn't know to read and write Marathi, that means he has turned hostile. He is not aware. So this cross-examination is a very important part, and it's the crux of finding out truth from the so-called witnesses which are produced in the court. The third part is re-examination. This hardly happens, but sometimes it does. Now, examination in chief could be also of the witness and also of the informant. The victim herself or himself has narrated a story saying such and such thing happened and such thing happened and it led to a certain crime. Now, if in between somewhere there is reconciliation happening between the accused and the victim, then the informant, the victim, could actually go back on her or his statement and say give some statements which are not supporting the prosecution. Her own story is not being supported by her statements. Then the prosecution will ask for permission to the court and ask such questions which will support her case. That is called re-examination. So that is basically reconducting chief examination or examination in chief. Now section 141 talks about leading questions. All those questions which lead to an answer is leading question. So basically it is like putting an answer in the mouth of the witness in simple words. So you ask questions such as, is your name Akshay Khanna? So he's going to, yes, my name is Akshay Khanna. So you've actually given him the answer and he's just saying yes. That's a leading question. Such questions are asked by prosecution so that he gives the perfect answer that we want to come on record of the court of the case. Section 145 talks about cross-examination as to previous statements in writing. So basically a statement is recorded in writing. You can't actually record it in electronic format, right? They have to be written down and typed and printed. So it talks about cross-examination pertaining to such statements which are given earlier in their earlier maybe examinations. Section 148 talks about court to decide when a question shall be asked and when witness is compelled to answer. Now, you might have heard of people saying that you may be excused from answering. You have the right to stay quiet, but it will be decided by the court whether the question is legible, whether the question is pertaining to the case. Only then the court will allow the advocate to ask that question. That's what it means. In examination of witness, there is also two sections more. Section 156, which talks about questions tending to corroborate evidence of a relevant fact, and that is admissible. Now, what all this means? This only means that there is a relevant fact in the case, and the witness who's called for giving statement is actually supporting. Corroborate only means support, to support. So his statement is basically supporting the evidence that was admitted in the court as a relevant fact. Now, this statement is also admissible, and such questions which actually get these answers is also admissible in the court. Now, when we say what is admissible and what is not admissible in the court of law pertaining to a case or a situation, this is the answer where it comes from. So basically, examination of witness chapter 10 tells us what is relevant and what is not relevant with respect to a case. What is it that you can ask and what is it that is not taken on record as an evidence. Section 162 talks about production of documents. So if you have to produce certain documents which support your case, this is the section that you have to evoke while you are doing so. I have mentioned 3 cases here for your benefit. Sarvan Singh is a case wherein it talks about failure of cross-examination, how it can actually, you go on asking questions for supporting your case, but the answers come in such a way that it supports the prosecution case. And that's where your cross-examination has totally failed. It's not going in your favor, but going in the favor of the state. State of Punjab versus Gurmeet Singh talks about asking questions which are valid, but these questions should not really harass the witness. So you can go through this case. It's a 1996 matter. Madhusudan Singh versus State is again 1996 case, and it talks about FIR not being a substantive document. Now, why? Because FIR is written by the police. Once they catch hold of a person, they see what has happened and they write certain sections of IPC. Say they have written 457, 353, 511, read with 34, all those kind of things in FIR. But while making the charge sheet, all the charges have to be ascertained, confirmed by the judge, and whichever written in the FIR, and then they get confirmed. So once the charge sheet is done, then you know that the person is booked under what charges. So FIR is not really a very good document as far as admissibility in the court of law is concerned. That's the reason why it says it's not a substantive or a substantial document. Now there is something called as burden of proof, which is included in chapter 7. What is burden of proof? Basically, it's up to you to prove your case, right? the state will say that the crime was committed, but you have to prove that the person has not committed the crime and he is innocent. So the burden of proof lies upon you to prove your innocence. That's what it means. Section 101 talks about it, and you should know the definition of burden of proof to write in exams. Section 102 talks about on whom burden of proof lies. As I said, in criminal matters, the burden of proof to prove the guilt lies upon the prosecution, and the burden of proof to prove that you are innocent lies on the advocate of the accused, because you want to set him free. So basically, it talks about the fundamental right of the accused to prove his innocence, but the prosecution will try to prove that he is guilty of that crime. So the burden of proof is lying upon the prosecution to prove his guilt and prove their case. Whatever is written in FIR, whatever charges are pressed against him in charge sheet. Section 103 talks about as to particular fact. So basically, if there is a fact which is included in the matter, then that has to be proved to prove your case. That's what it means. Section 108 talks about to prove a person alive, not heard of for 7 years. Now, this is very interesting. Also in matrimonial matters, this could be included. See, a person who knows you, your friends, your family, your neighbors, see you every day. Say you go out on a vacation for a month, but even after a month, they will see you somewhere. And you, maybe somebody may call you up, not heard of. It could be seen or heard or whatever. So whoever is in touch with you should know that you are somewhere on this earth. But maybe you just become absconding. You're nowhere, and that too for 7 years. Then law supposes that the person is presumed to be dead. But if you have to prove that the person is alive, the burden of proof lies on you. That's what section 108 talks about. Section 110 talks about as to ownership. If you want to prove that there's some property which is in your name, say the ownership is yours. So the question is whether any person is a owner of that property, whether it is in his possession or not. The burden of proving that he is not the owner is on the person who affirms that he is not an owner. So basically, the person, in simple words, the person who is trying to prove that whether A has happened or A has not happened lies with the person. Say, for example, you say that you have not stolen your friend's pen. The burden of proving that fact lies upon you and nobody else. That's what simple logic of this chapter is. 113A talks about abetment of suicide by married women. Now, this comes in dowry deaths or suicide committed by married women within 3 years of their marriage. And if the in-laws have been harassing her, so that is called as abetment of suicide. So 113A talks about that, and 113B explicitly talks about dowry death. Whether it was a suicide committed because the in-laws were asking for dowry is a matter in question for 113B. I have included Ram Swarup versus State and Gajendra Singh versus State. These are quite old but nice cases which talk about burden of proof. Now, presumption as to documents, this is included in chapter 5. These are the relevant sections. Section 79 talks about genuineness of certified copies. Now, if you have taken it from the court, there are stamps, there are signatures of the relevant people, then of course it's a genuine document. That's what section 79 talks about. On what basis are you taking certified copies from lower courts and furnishing it to higher courts to support your case? Because they are genuine as per section 79 of chapter 5 of Evidence Act. That's what it means. Section 80 talks about documents produced as record of evidence. That only means that whatever documents you have given to the court as an evidence to support your case are admissible under section 80. Section 81 talks about gazettes, newspapers, and other documents being relevant as they are presumed. Now, why is it included under this topic is because they are presumed as documents which are admissible as evidence in the court of law. So there is no dispute unless you prove that they are fake, but gazettes, newspapers, certified copies are all prima facie considered to be true. Section 84 includes collection of laws and reports of decisions. So basically, if you have furnished an order of the lower court to be considered or reconsidered in the higher court, this is the section that you need to evoke. As per section 84, the order of the court is considered as an evidence. Section 87 talks about books, maps, and charts. Section 90 talks about documents which are 30 years old. Now, it is presumed in property law, in civil matters, that the documents which are very old, they may not survive. The paper just withers away, the writing goes away. There could be a will which is like 40 years old. You may be able to see the content which is printed, but is the signature of the person still there on the paper? It must have just vanished because it is too old. So under section 90, you can argue that the document is still valid and can be taken on record as an evidence because it is 30 years old, and you can prove the case with supporting documents. You cannot just give one, you will have to furnish certain other documents as well. Say, for example, you give a photocopy as a secondary evidence, but secondary evidence in itself will not be presumed or taken as an evidence on record unless you prove that there is a primary evidence to that secondary evidence. So basically, you have the real will, the actual will, but there are certain words or a part of the signature which has just gone away because it is very old, and you give a photocopy which is very clear, and when matched by the forensic expert or handwriting expert, yes, they are same thing. So the copy, the Xerox or the photocopy is actually the Xerox or the photocopy of the actual will. The real will is what section 90 talks about. Section 90A talks about electronic records, which is 5 years old. So as we know, electronic records survive more than documents which are on paper or maps or whatever that is. But here in 90A, they want to certain that the record is true even though it is 5 years old, because even electronic records can get spoiled. Say, for example, you have a cassette of songs and you have played it over and over and over and over. The songs which are recorded in the tape are the say the evidence. It's the content of the tape, and the tape is too old now. Over the 5 years, you are not able to hear it properly. Some words are missing. You're not able to hear certain words of the song. Still, you can evoke section 90A and make it admissible in the court of law, arguing that the relevant part which you require is quite clearly and quite nicely audible in the court. So I have included Modi Ganga versus State. It's a 1981 case which talks about how documents are presumed to be taken on record as an evidence. Exclusion of oral. Now this is included in chapter 6 and it starts from section 91. Evidence of terms of contract, grants and other dispositions of property reduced to form of document. Now there could be certain other documents which ascertain the terms and conditions of a contract. Now whether they can be included or not is what is written in section 91. Section 92 talks about of oral agreement. Now what is it exactly? Basically, there could be exclusion of evidence of oral agreements when the terms of any such contract, basically this is all about contract because it is in written format, grant or other disposition or any other matter which is required by the law, it has to be reduced to the form of a document and they have to be proved according to the section 91. So section 91 and 92 are related to each other, and no other evidence of any oral agreement or statement is to be admitted because you can see it on paper, right? So you cannot really give a statement with respect to the real document, and that's where exclusion, that's what is called exclusion of oral. Oral means statements which are made, oral evidence. Section 93 talks about to explain or amend ambiguous document. Now you have to prove a document with the help of a document to support your case. You cannot really go and explain it because there is ambiguity, right? So say, for example, you have two mark sheets and both are of the same semester, but in one mark sheet you have 91 marks and some other mark sheet says 81 marks. Maybe there is some misprint from where it has come, so you cannot just go and explain. You may have to get the real copy again. So your oral evidence or your statement will not support any document. You are going to say yes, 91 marks are my is my score for the subject. You will not say 81, right? So there's little ambiguity with the document, and you cannot just go and say tell a statement or make an oral submission. That's what section 93 talks about. Section 94 talks about anything that is against application of document to existing facts. Now to prove an existing fact, you may furnish more evidences in the court of law, but when there is any language which is used in a document which is ambiguous or which is defective in nature, it may not be given of facts which should show its meaning or supply its defect. You cannot really furnish any statements to prove either of them. So you cannot, basically the whole exclusion of oral evidence included in chapter 6 talks about the fact that you cannot give a statement to prove one document from the other when there is ambiguity between the two, because any person who's going to come and give a statement is going to talk in his own favor. So how is the court going to understand who is lying and who is telling the truth? So basically that's the reason why exclusion of oral evidence in chapter 6 is included from 91 to other sections. Section 98 talks about as to meaning of illegible characters. So basically something that is not you are not able to read, something that is not visible, it's not legible. Section 99 talks about who may give evidence of agreement, varying terms of document. Now there is a contract between two people. They are conducting a business and both have documents, a document that is the contract, but the terms and conditions mentioned in the agreement or the contract is little different. So whose document will be really considered as an evidence is given in section 99. Circumstantial evidence. Now, circumstantial evidence is something I also mentioned yesterday, Sharad Dirdijan Sanda versus State. If you read this case, this is very interesting. How a case is built seriously on the base, only on the basis of circumstantial evidence. So because you don't have a direct evidence. Now, what is direct evidence? Direct evidence is something that directly ascertains or tells that an incident has occurred. But circumstantial is when you connect dots and you lead to a path wherein you say that this might have happened. The chances are that that could have happened 80 to 90%. Now it depends on you and your evidences which you furnish, wherein you build your case with the help of circumstantial evidence to prove your case. So circumstantial evidence is basically something that only you might have known that the case you hear often. There is something called as facts and circumstances of the case. So facts is something that has really happened, which is stated as a fact by somebody, and circumstances in what situation it has happened. So that is exactly what is circumstantial evidence. So I have written down certain points. If you elaborate these in your answer, then you will score really well. Guilt must be fully established. Any circumstantial evidence should not leave room for the judge or the court to think that the person is innocent, because he has to be proven guilty beyond reasonable doubt, as I said yesterday as well. Should establish the guilt of the accused. Second point is facts should be consistent with hypotheses of guilt of accused. So as you build a story, you testify or you tell the court certain facts that have happened. Certain, say, for example, incident A took place, incident B took place, incident C took place. They are in a chain. It's a chain of events. A happened, then B happened, then C happened, and ultimately D, that's the crime has taken place. So these facts, A, B, C, D, should be consistent with the story. That's the hypothesis that you are trying to built against the accused to prove that he is guilty. Circumstances should be conclusive and in nature and tendency. So basically, all the circumstances that you are narrating to the court should be in such a manner that leave, as I said earlier, there should not be any space for the other advocate to think or the judge to think that it is not true. There should not be any confusion in that. That's the reason why it should be in conclusive nature and tendency. They should include all other possibilities. So basically, if you are saying that X person was on Churchgate station on 7th of December, you should not leave any room for the person to say that no, he was on, say, Andheri station. So you should exclude all other possibilities. When you make a statement that he was at Churchgate station, you should furnish an evidence that, okay, he's seen at 7:30 p.m. in the CCTV recording of the station. So you are basically excluding all other possibilities of him being at any other station, which could be a defense for the advocate of the accused. So that's what circumstantial evidence says about excluding all other possibilities. That's very important. Chain of evidence to prove only guilt and no reasonable ground to establish innocence. So basically, all the facts, all the circumstances that you have narrated, all the evidences that you have furnished should not give even a single chance to the advocate of the accused to establish that no, he's not guilty of that crime but innocent. So as we mentioned earlier, the burden of proof of proving the guilt of the accused lies with the prosecution, that is the state, and if there is circumstantial evidence included or involved in the case, then the chain of evidences which are being furnished by the prosecution to the court should only prove the guilt of the accused. And this is all very nicely included in this case law. You may go through. Next talks about direct evidence, which is included in section 60. Now we all know what is direct evidence. It establishes a particular fact. Say A has killed B with a knife. So this is a fact and it establishes that the person has committed crime. Now, direct evidence in this case could be CCTV footage, wherein it is seen in the recording that A is actually killing B. That's a direct evidence. As per section 60. It should support the truth, whether it is the guilty mind or the guilt of the accused or the innocence of the accused. So it should always support the truth. It should directly prove or disprove a fact. As we said, innocence or guilt, so it should prove or disprove a fact. There is no need of intervening evidence. Now, what is intervening evidence? Something that you give in support. Now, if you have circumstantial evidence on record, then you may have to furnish more evidences to support your story. That is intervening evidence. Now, if you have a direct evidence, then you don't need to give more evidences. Not only CCTV footage, it could be a person who's seen A committing the crime. That's a direct evidence. Now, what is first-hand or personal testimony? The person who has seen A committing the crime is first-hand or a personal testimony that he is saying on oath to the court that he has seen A actually killing B. Next point is exactly that, directly observed or experienced. A sees a murder, narrates the story. That's the direct evidence, simply what I have included. Now, this is a very good case, Shivaji Sahebrao Bobde. It's quite an old case, but very easy to understand. You can include this in your answer. I'm sure you will convey to the person who's checking a paper that you've really understood what is direct evidence and what is exactly given in section 60. Now we end our session here. You may ask your questions.
Ma'am, can you just explain the distinguish between the estoppel and admission?
Okay, so see, admission is a statement that is being given by a person, okay, or a document that you have furnished, okay, it's admitted in the court. Estoppel is where you go back on your answer. Say, for example, you have a witness in the court of law who has given a document saying that this is true. That's admission. Okay. If he comes and tells, that's a confession. Right? Now, estoppel is on the next occasion, he comes to the court and says that that wasn't true. He is actually denying the statement that he had given in the first place. That's where, as per law of estoppel, he is not allowed to go back on his answer. So he will be declared as hostile witness. I hope you have understood.
Can you explain that PPT section 141 and 145 chief examination and re-examination again, please?
Oh dear, this is very easy. So basically, say a person is called as an eyewitness in the court. Now there will be two sides, state versus some accused, say Vijay. Now the state will be represented by public prosecutor. Now the public prosecutor will ask certain questions to the witness to prove the guilt of the accused. Whatever questions the public prosecutor asks is chief examination. That's basically the story that the witness is going to narrate, whatever he has seen, heard, or felt, whatever he has experienced with respect to the crime. The story that he tells, that is chief examination. Now, next step is cross examination. So once chief is conducted, it is the turn of the accused, advocate of the accused, to prove his case, that the accused is innocent. Okay, so he will cross question the witness to prove that whatever that statements the witness has given are wrong. Either he falsely believes in them or he is lying. So you have the advocate of the accused will ask such questions which will actually prove him wrong. That's called cross examination. Once this is done, say the witness turns hostile. Okay, he's got some money from the accused and he no more is interested in coming to the court and appearing and giving statements. Then whatever statements he will make will not support or will not be in consonance with the statements which he has given earlier for chief examination. In that case, what happens is the case of prosecution fails, right? They are not able to prove their case because the person is giving all wrong answers. Then, with the permission of the court, the public prosecutor may again ask him such questions which will narrate the story again which he had told in the first place in the chief examination. That is called re-examination. If you have a situational problem, you can ask me. I will let you know how to decipher between them.
Okay, thank you, madam.
As you just explained on that re-examination, so basically re-examination will be held by the prosecution itself, right?
Yes.
Okay, so there is no chance like after the re-examination, can the
Hmm.
cross-examiner, like the accused advocate can cross-examine again?
There is no need. He's supposed to do his job in the first place when he had got turned to cross-examine him. Basically, see, the prosecution will try to extract whatever is in their favor, right? So in the first place, when he had told the story in chief examination, the advocate for accused is supposed to cross-question him in such a way that you prove him false. So there is no
Right.
need for the advocate to conduct a cross again. Generally,
No.
that doesn't happen and there is no provision, there's no need.
No, basically, like as you just said, that if there is an like chance of re-examination, so the
Yes,
prosecution have conducted the re-examination. Okay,
correct.
so like after that sort of questions which was asked in re-examination, can the advocate for accused cross-examine the witness again? Like,
That's
is
what
there
I'm
any
trying
kind
to
of
say.
chance?
That see, even if re-examination is conducted, the
Hmm.
questions will be same in some other words. Just
Okay.
because the witness is trying to give a wrong impression.
Hmm.
So the
Okay.
prosecution wants to extract answers in their favor. So there is no need for cross-examination.
All
Again,
right. Thank you.
My
most.
question is regarding Estoppel
Hmm.
and its exceptions. I read somewhere that criminal and quasi-criminal matters are the exception to Estoppel. So coming back to the question of one of the participants, I was a little unclear. So the confessions are an exception to Estoppel, right? So the confessions can be retracted. Am I correct?
Yeah, then the person will be declared hostile. It's not in your favor.
No, but if the confessions are done in police custody or under influence, threat, promise, etc., so
Like
then
this
they,
case
as it
was.
is, don't stand the ground, right? So they won't be
Very true.
called as hostile.
Very true. As per rule of Estoppel, they
Huh.
are not included then.
Okay, so confessions are.
See,
So
basically,
Sumedha, I mean, what she's asking is in case, in the police custody statement is made and then when the lawyer contacts, okay, and
Or
then
even the
the
magistrate
accused,
is present in front of magistrate.
an accused realizes that he didn't get the question properly and he made a wrong, so it can be retracted, right? Is that what you are trying to ask?
Yes, exactly.
See, first place, you have to understand that any statement made in the custody of police is a self-incriminating
Inadmissible,
statement.
yes.
Yeah, and that is not admissible because it is believed that when in custody, they are under threat or they are under
Yes.
stress. They may tell anything. They may not tell the truth. So
course.
under pressure, they may say, yes, I committed the crime. So it's
Yes.
not admissible in any case.
Okay.
Ma'am, the confession given during the medical examination to the doctor will have a binding effect on the accused.
See, I tell you, when a medical examination is going on, I think it is up to the doctor to understand because he will do certain tests and then he will come to know from the report, right? So this is basically a little of a documentary and direct evidence, and he need not really listen to the person. Say, for example, I'll tell you, A was driving a car rashly, okay? He hit a guy and B fell down and he got hit. Now, the person may say that, you know, his head is aching, his leg is aching, he needs to he's not able to breathe or whatever. Okay, see, when a person is under stress or under tension, you may start feeling a lot of things. You may feel that your heart is not pumping, your head is aching, whatever. So it is up to the doctor to examine him and understand what kind of injuries he has suffered, whether they are grave and whether he has suffered any internal injuries or no. That the person will not know. He is not a medical expert. The doctor knows what it. So in medical thing, if you are saying, confessions are not of that standing. It's up to the doctor to prove the case. So he will be called to the court as an expert witness and he will explain as to how the person was brought to the hospital, in what situation. Maybe the person had fainted, he was bleeding, his head had a crack, or he's suffered a fracture. So all that the doctor has to tell the court, that these confessions will not be of any standing in that.
Okay, ma'am. But if the accused tell the doctor that he has committed some so and so crime, so will that have any binding effect on the accused?
No. See, basically, any confessions made by the accused are of no use because even though the prosecution will say he has himself, told such and such person that he has committed a crime, that will not be of any standing until and unless he pleads guilty in the court. So, if, for example, when people are caught and brought in the court under NDPS drugs cases, they have small quantity, say little, some 1 gram or something, which is a small quantity. They are asked whether it was with them. They say yes. They plead guilty. They are pressed a fine of 2,000 rupees. They pay it and they go away. So basically, if they plead guilty, yes. But if he's telling someone else, it is of no use. May it be police, doctor, anybody, neighbor, it's of no use. Only if he pleads guilty in the court, it will be taken as a valid statement in front of the magistrate.
No, I asked you this question since it was asked in the past papers. It says that the question says that during the medical examination, the accused confessed before the doctor and the police officer or the constable overheard this conversation.
It's of no use. Even if he directly tells the police, it's of no use. Because these are self-incriminating statements are inadmissible in the court of law.
Okay, ma'am. Okay. Thank you, ma'am.
Can you just brief us about the rule as to produce the notice?
Role as in what exactly?
Actually, there was a question in short notes which state that rule as to notice to produce.
Okay, so you have to write the contents of that section in your answer.
So rule as to produce notice to produce evidence, right, Sumedha?
Yeah.
This must be a unique question.
Actually, this is not very important. I don't know why they are starting to give such questions to students. Can you tell me the section?
Actually,
66. So is this a situational problem by any chance?
It's a
no,
short
ma'am,
note.
short note.
Short
Yes.
note. Okay, so
Yes,
what
yes.
you find in your textbook is secondary evidence of the contents of the documents referred to in section 65. So it talks about section 65 clause A shall
Okay.
not be done unless the party proposing to give such secondary evidence has previously given to the party in whose possession of power the document is, or to his attorney pleader such notice to produce. Produce what? The document as is prescribed by law, and if no notice is prescribed by law, then such notice as the court considers reasonable. So basically it is talking about notice being sent to the person to produce a certain document as an evidence in the court.
Okay, so this notice would be basically sent by the person who is willing to procure the particular document, right, ma'am? Or am I wrong?
See, these kind of notices may mostly be given by advocates, or they could be summoned by the court because they need a supporting evidence, because it is clearly talking about secondary evidence, and secondary
Okay.
evidence are always in support of a primary evidence, and the court feels that the primary evidence is not sufficient and they require more evidence to be very sure whether the thing has happened or not, yes or no. So that's the reason why they are asking for more evidences. That is the secondary evidence.
Okay, ma'am. Clear. Thank you so much.
Welcome.
Section 65, the person wants you to elaborate. The participant is requesting you to elaborate on section 65.
So basically section 65 talks about secondary evidence which can be furnished in the court of law for proving the case in consonance with whatever, say if there is a document and there are certain contents of the document or the conditions are mentioned, then that's what section 65 talks about. It basically says when secondary evidence can be actually given, in what circumstances. So the circumstances in which they can be given are strictly regulated by the Act, and they are listed in section 65. The section provides that secondary evidence can be given in the following cases. One, when the original is shown. As I said, secondary evidence cannot stand on its own. It has to be furnished only after giving primary evidence. So basically it's a photocopy or a certified copy, such like a copy of the original. So it cannot stand on its own. So it can be given only when the original is shown or appears to be in the possession or the power of the person who is furnishing the document to be proved. And second is when the existence, condition or contents have been proved already. They are admitted by the court in writing. Third is where the original is actually destroyed or lost. You can write these conditions. You need to mention it in your answers. If you like, you want it on a short note type kind of an answer. Fourth condition is when it is a very bulky document. Say, for example, you have a 2-hour CCTV footage. You can't waste time of the court looking at 2 hours footage, right? Video. So you have to put it in writing, and only that relevant part which is pertaining to the case. It may be a 2-hour, say, marriage anniversary party. But if the crime has been committed while cutting the cake, that's the relevant portion that you put it in writing and then furnish. So when you're putting it in writing, the CCTV footage is primary evidence and the written thing is a secondary evidence. So when it is in bulky format or it's a bulky document, you can furnish secondary. So basically conditions are given in what situations you can give secondary evidence and they are considered as admissible in the court. That's what section 65 talks about. Fifth point is if it's a public document. So we saw what is public document within section, meaning of section 74. Sixth point is when the original is a document of which Evidence Act or any other law of country permits certified copies. So it's talking about certified copies. And seventh is original consists of numerous accounts or it cannot be conveniently examined in the court. You cannot take every other big thing in the court. You have to reduce it to writing or you have to take a copy of it as to just to make the process and the whole furnishing of evidences easy. So these are 7 conditions wherein you can actually furnish secondary evidence. So section 65 talks about circumstances or situations or conditions in which secondary evidences are considered or given weightage as far as admissibility of that evidence is concerned. I hope it is clear.
Yeah, any last tips that you want to give?
First thing is don't be anxious. Don't be scared that you have evidence examination because it's really easy. Try to connect simple things. We see lot of movies. These days, there are a lot of movies on crime and you could relate very easily. So you don't have to really remember the exact words of the Bear Act. I'm sure from all the questions that were asked today and yesterday by all the students, you have studied really well. Be confident. This is a very simple concept if you understand. exam, and I'm sure you have already understood it from what you asked. So going back to tips, one is read your definitions. If you don't express it the way textbook talks about it, it's okay, but you write it in your exam. Secondly, as far as possible, write your illustrations. If you open your Bare Act, you will get umpteen illustrations which will support your answer. All it is A and B. You will remember it as a story. You will easily be able to express it. If possible, write case law. If you are not able to remember the citation, please don't worry, because many a times it happens that when you go for exam, you go blank. But if you remember the case, only this versus this, that's fine. Say Sharad Dirdichand Sarda versus state. It is state of Maharashtra. But if you don't remember Maharashtra, Karnataka, which high court it is, don't bother. Just write state. That is more than sufficient. Evidence law is basically applicable, or on a large purview, if you see, it is applicable to criminal cases. It is mostly versus state. So always go for it. All cases that I have given are Supreme Court cases. So even if you mention in a Supreme Court case of so-and-so versus state, it is more than sufficient for the person to understand that you know the case. Don't worry about anything that you forget. Even if you forget little things, that's fine. If you omit certain words from the text or the Bare Act, don't bother. Express and your understanding of the concept. In long answers, don't worry about filling 5 to 6 pages. If that's what you have been told, just write your answer, structure it well in distinct points, make short, simple, write it in simple language, and make different paragraphs. Leave a line between two paragraphs. They are going to give you answer sheets if you require. Don't worry about that. Don't just rush with your paper and write it. While selecting your questions that you want to attempt, be sure that you know what it is about. Even if you forget your sections, say for example, 135 to 162 talks about examination of witness. You don't remember, don't write wrong sections. Even if you write it is included in chapter 10, it is more than sufficient. Express in simple words, write simple answers, and write down the points, whatever that you have understood. And don't go by the language of the textbook. That's one big mistake that students do. They get very intimidated by the Bare Act. Bare Act is only for writing, say, illustrations. All the case laws that I've mentioned in my PPT today are taken from the Bare Act. So don't worry, you have already seen them. Thank you.